May I, Lordship?
Yes.
Lordship, I would like to mention item number 1.
Why?
Lordship, I'm appearing on behalf of the senior counsel Kashyap.
Then again, you are thinking that
He comes from Delhi, so due to
doesn't
some
matter.
personal difficulties, he could not be available today.
It's nothing. You are
Oh.
challenging the 2024 NIT. The works have already been completed. There's nothing.
Lordship, matter may be fixed
So
after
every time when the matter is listed, it's been a job.
senior has instructed, so
You have to adjust. We have fixed the matter on your last prayer. We have adjourned it. What you do?
adjournment may be granted.
We are not inclined. When your senior can appear
After 4 weeks.
tomorrow,
After 4 weeks.
we're granting the last chance. Just because your senior is not there, otherwise we would not have. We are not inclined. Mr.
Techi.
D.
Techi.
Techi,
Yes.
Learned Counsel appearing on behalf of Mr.
Kashyap.
A. Kashyap, who stated to be an outstation lawyer, phrase for adjournment of the matter for 4 weeks. Listed. Next better. Records reveals that this president appeal. Agent when several on several occasions, the appellant, the land counsel of the appellant has sought for time for which this court has granted. Mr. Considering about let this matter be listed after 4 weeks. Mr. It is made clear that no further adjournment shall be granted.
Much obliged.
Inform your senior.
Item number 2.
Ma'am, please develop.
Yes.
Lordship, this matter is also supposed to be appeared by one, the counsel from the Supreme
What's
Court.
wrong with the judgment?
But the judgment, to that extent, my lord,
Very
The-
elaborate judgment.
elaborate judgment, my lord, issue is very simple. But the, my lord, release has been granted.
Okay.
Appellate,
How can the district judge grant the
my lord, he is the, she was at that relevant point of time serving under the administrative control of the, my lord, the district and session judge, my lord. There was no, my lord, the rules.
that has been explained clearly
My lord, that
by
explained.
this judgment.
And my lord, my lord, the pass by the, my lord, the order passed by the, my lord, the honorable single judge. He is basically relied on the 235 of the, my lord, Constitution of India.
Yes.
Which talk about, my lord, my lord, the limited understanding is, my lord, it is in respect of, my lord, the judicial officer, my lord, subordinate officer, and the inferior to the subordinate, my lord.
The staff of the
Staff, my lord, if we once, my lord, the peruse again, my lord, there is no whisper about the, my lord, the staff of the, my lord, that establishment. Now, my lord, the new rules has come, wherein, my lord, it has been specifically mentioned, the lacunas, my lord, which has not been at all at that relevant point of time, has been, my lord, came into force now. Now, my lord. So, therefore, my lord, we are, my lord, agree by the order, my lord, passed by the honorable single bench, by which, my lord, the release order has been cancelled, recalled, and the revocation has been, my lord, performed.
You go back if you are interested in the.
Admittedly,
job.
admittedly, I'm facing the departmental inquiry and the disciplinary proceedings. So till such time, may I present notice may be issued. This may be admitted. This is required to be examined in detail. And that has to be heard by.
Are you after the issue, I mean, preview with the rules, according to you now, the district judge has no power.
Admittedly, after subsequent amendment, subsequent there is a guideline. Now the guideline by way of press guideline, the lacunas has been filled up.
No, the district judge is supposed to take the permission from the High Court, the administrative side.
As I pointed out, there is no rule as such, where by which the administrative approval has to be sought from the
Of the High Court,
madam.
under the control of the High Court,
As per the judicial service rule,
appointment and transfer and posting from one place to another, district judge may have the power. They have the power of that.
if we
You are sending on deputation, under which, what rule you have been released? Is there any rule?
since my administrative control, I am serving under the administrative control. The administrative controlling officer is the only authorized persons to release me, not other than man. Therefore, I apply to the
What is
Ah.
the rule?
there is no rule as
Then,
release.
if there is no rule,
Therefore, my submission is
the employees.
when there is no rule,
The judicial officers, the employees are under the administrative control of the High Court.
admittedly, my submission is
So are the rule.
my submission is in absence of rules, that benefit has to be given to me. It's because there is
There is no question of the benefit.
Malad-
You are clearly under the supervision of the High Court.
admittedly they have not gotten the provisions for the release.
Yes, what about any action initiated against the district judge? No. Why?
Not initiated against the district yet.
Have you read that last judgment, last order paragraph? That even after coming to learn about the illegalities committed, what the High Court ordered, you have not taken any action.
Admittedly, in our area, we have also prayed for the expansion of this particular
Oh, who, what?
it's because this is the observation made by the
You are challenging the authority of the High Court. Being the employee of the
True.
district judiciary.
Hello.
Show us any rule. That way you can be sent on deputation by the district judge. Other than Article 3 or 235 and 236.
I am sorry, therefore, this has to be supposed to be appeared by the council from the Supreme Court.
I think it's better if you want to be in a job, not pursue them. But not in fact.
This is for the ends of justice, notice to be
But not in fact to admit.
notice only,
Don't
so that
say
it can be heard.
you are committed.
As I've already pointed out, just I am being a local council of in this case, I am mediating. The main council is the Supreme Court.
What changes?
The matter was listed before his lordship, good Chief Justice, on the last.
Due regards, changed it.
Admittedly, but how that will be argued by that is the one the scope with the
Yes, it's not a one page, one to page, over
how
everything is discussed.
exactly, but my understanding is the issue is very limited. Whether the power judicial the district and sessions has the power to release his employees or no.
What release? It's not release simplicity.
Malad,
You are sending a person to on deputation,
on deputation.
on their asking. without looking into the provisions of the law.
True, man.
Better at stay.
But at this stage, my lord, notice me. So then,
In this case, question is only one. Before you be giving order, whether the district judge has taken any approval and consent from the Guwahati High Court.
What he's saying is, it is not required.
It is required as per Article 35, 235.
The
So
problem
it has
is,
already been decided. This can-
problem is, sir, we're ready to hear the matter. You are, what's there?
my lord, that is the specific.
Will hear you.
My lord, then may I bring the matter may be listed tomorrow, my lord. My lord, what I'm getting the information from the Supreme Court lawyer is not receiving any password, my lord. This morning also, my lord, on the day also, my lord, we are time
Password.
password, my lord.
It's very difficult. It's very difficult
But
for
if-
BC.
Yes, my lord.
BC, we cannot deny any person, including the lawyers. But then you have to.
Madam, we'll make a request to the madam, the counsel from Supreme Court, madam. May I pray the madam, the matter may be listed on Thursday, madam, so that he can come or madam, the alternative arrangement, madam. Thursday, madam.
We're not issuing notice.
Just for madam issuing notice, madam.
Uh, Mr. M. Kato, learned counsel, appearing on behalf of learned counsel for the applicant, submits that the leading counsel
But- Thursday. Madam, I'm sorry, madam.
It's okay.
This is the instruction which I have only received from the madam.
Let's discuss it on Tuesday. Give the date.
21.
Same level.
I like to mention item number 4 and 5.
4 and 5.
Yes. Wait will start for tomorrow, Lords.
Why?
Lords, because both the senior causes, they are on the way and they will be conducting case tomorrow. Mr. Dilip Ajuda will appear for petitioner and Mr. D. Das, Diganta Das will be for the respondent. No, Lords, because both the seniors have requested.
We cannot. We have to see the convenience of the court.
In that case, Lords, let
Not
no,
only convenience of the senior lawyer.
yes, Lords, in that case,
We understand.
in that case, Lords, let it be there in the list. Date may be given tomorrow.
Huh?
Let the matters be there in the list tomorrow, and both the councils will come and take a consensus date.
That will come.
I am told to make a request for day's accommodation.
Yes, accident. Let the council to take. Respond.
Yes.
On the ground that the senior councils appearing in these matters are
They are already
way
yes.
to the court, therefore. Wait for the speak of the matter on.
Board.
MS. So.
Your Lordship, I beg to mention item number 21.
21.
Your Lordship. I'm appearing on behalf of leading counsel Elbam, Your Lordship.
That's there.
Lordship. Leading counsel, Your Lordship, he is having some health issues, Your Lordship. What if he couldn't appear today?
What's the matter?
Your Lordship, there was a domestic meeting among family, Your Lordship, in which the matter regarding the meeting was,
Land dispute. Land dispute.
Your Lordship, I'm not exactly aware of the facts. Your Lordship, I'm aware of the facts, but not exactly about the meeting.
Matter is still court.
Yes, Your Lordship.
24 mentioned you have to have the facts of the matter.
This is, Your Lordship, regarding quashing of a Parwana issued by the,
That's not go to the civil court. Matter is in dispute.
yes, Your Lordship, this is a matter where CO have,
You try. That's the point.
Your Lordship,
Do you have the brief?
no, Your Lordship,
Give the second point.
I'm not in this matter, Your Lordship.
Will allow you to argue. Moment. Give the second point.
Mayor Lordship.
Yes.
Lordship, in this suit, I am challenging the order dated 11/7/2024, passed 35, passed by the ADC.
Debate is there.
Yes, Your Honor. Lordship.
Yes. Heard MS.
Hey, right.
Hey, right. That consequently. The good mistakes. Which was. Yes, when the Indian order. What is the impugn order?
Yes, impugn order is on the page. Your Honor, you'll see annexure for page number 34.
34.
Yes. Your Lordship, in here, this impugn order is passed as per the complaint by the respondent number 3.
Yes.
Yes, who is the mother, second mother of respondent number, sorry, petitioner number 2, Your Lordship. Your Lordship, in here, may I, Your Lordship, the gist of the case is that the petition number 1 has acquired a plot of land, and in the year of 2011, Your Lordship. Since then, in the same year, he has constructed an RCC building in that plot of land. Since then, that particular plot of land is under my possession, peaceful possession, since more than a decade, Your Lordship.
It's okay. Don't let us not go to the Ramayana. Come
Yes,
to
sir.
page 35.
So, Lordship, in this impugn order, the problem here
Page
is that
35, you read the last topic.
Yeah.
After serial number 6.
35, yes, sir. May I, Your Lordship? In view of above facts and circumstances, and as per cadastral survey map and land allotted file of Srimati Margam Dabi, was well as from the statement of Sri Takek Lombi Mandal dated 2/5/2025, it is found that the land allotted to Srimati Margam Dabi through transfer from late Bomar Dabi and the land claim and freshly applied for allotment by Sri Nyatong Gomdir, who is petition number 1, is the same plot of land adjacent to Army at Siom Colony.
Yes. If it is same plot of land, then
Your Honor, Your Lordship, this is not the fact actually here, Your Lordship.
if we are not going into the, this, the report, we're not going to the disputed question of facts. If it's not a facts, it's a disputed.
Yes, it's a dispute, Your Lordship.
So
May I, Your Lordship, if I may,
then you read further.
further in the next page 36, it says that,
The land management is hereby directed.
yes, yeah.
Management department is hereby directed to demarcate the allotted plot of Sri
Margam Dabi in presence of sector magistrate measuring 252 square meter as per the allotted map, that is 14 meter along the highway and 18 meter towards the Yomgo River by maintaining 2.5 meter from army fencing. The plot of demarcated should be properly marked with pillar, plant, and geotech. It is also further advised to properly verify and publicly notify before processing any land allotment transfer to avoid overlapping of land allotment. That's much, Your Lordship. And Your Lordship, if I may, Lordship, may come to the page 13, that is Annexure 1, Your Lordship.
Yes.
This is the passbook of allotment passbook of Srimati Margam Dabi Ngomdir, petition number 2. So, in page number 14, Your Lordship, if I may, the point 6, boundary description. If you don't make the boundary description, if you, you don't may say,
Fencing.
in the north side, this is Hume Colony River. And in the south, it is PRTF road, that's highway road. And east is the army fencing, that's army area. In the west is the boundary of the Bomar Dabi, late Bomar Dabi. By seeing that only it is clear that Your Lordship, in the east side, there was used to be army fencing. And this passbook is updated 2015, Your Lordship. If my Lordship may come to the page 31A, that is the map. 31A, Your Lordship.
So according to your land is a separate land.
Yes, my land is separate land. It is not, actually the total land of 1,000 square meter was allotted in the name of
Bombardam.
Bomar Dabi, late Bomar Dabi.
But then there is only 252.
252 was yes, gifted to the petition number 2.
How
Your
can
Lordship.
he give that?
It was gifted to her and subsequently she had already allotted that 252 square meter of land in her name. Petition number 2. That is the passbook.
You are also the family members.
Yes,
Yato up there.
Your Lordship, Margam Dabi Ngomdir is the daughter of the late Bomar Dabi. And the petition number 3 is her stepmother. During the lifetime of the father of a petitioner number 2,
So you are
there is no
claiming,
any dispute, Your Lordship.
you are claiming 252 square meter.
Pardon, Your Lordship?
Are you claiming 252 square meters?
No, Your Lordship. The 252 square meter is clear.
Ah.
The disputed land here is that petitioner number 1 has occupied just adjacent to this 252 meter of land, occupied the plot of land. That is 416 square meter in total, for which I have already allotted, applied application for the allotment. That's in the page number annexure, that means that is page number 17. And also I have obtained NOCs from the concerned department. And that was dated in the year of 2020, Your Lordship. And this complaint by the respondent number 3 came in the year of 2024 only. And the land was occupied by me during the 2011. That's more than a decade, 14 years, more than 14 years, Your Lordship.
So according to
Till
you,
then,
according to you, 252 square meter is clear. Which
Yes.
has been given to you on whether legally or illegally gifted to you
Your Lord,
by your father
yes, Your Lordship.
or the
Lordship.
father-in-law.
Yes, and father-in-law of the petitioner number 1 and father of petitioner number 2.
Yes. So there's no dispute.
There is no dispute, Your
The
Lordship. The
dispute is
that land here is the land which petition number 1 has occupied. That is 416 square meter land. That is shown in the map also. Map.
have you been allotted?
Your Lordship, I have been not allotted. I have
So,
already
What
applied
is
for
it?
the
What is
allotment.
It's a government land.
Earlier it was, Your Lordship. Yes, I have, but there is NOCs also. I have already applied for
Because you will not give any.
application, Your Lordship. And actually, Your Lordship, the dispute here is, as per the respondent number 3, they are claiming that my land comes under their 1,000 square meter allotted land, which was allotted in the year 1997
Appears
to
to
late
appears to be.
Bomar Dabi. Yes, but
Appears to be.
that's why I'm
Therefore, the ADC has a state officer or who? ADC
yes, ADC come state officer, Your Lordship.
has said that it's one in the same plot. Then claim previously applied for allotments is the same plot of land adjacent to army. Yes, same plot of land.
No, Lordship, it's not the same plot of land. That's why I'm trying to establish here, Your Lordship. If you as per I
Then
said,
you file a suit that it's not it's in a different land. It's a disputed now.
yes, Your Lordship, it's a different land because, Your Lordship, That's what I'm trying to establish here, Your Lordship. In the page number 14, that is the first book of
See, you read that land management is hereby directed to demarcate the allotted plot of Sri Margam Dabi in the presence of sector so and so 250 meters as per allotted.
and Your Lordship, there was
And the plot so demarcation should be properly. However, disposal case shall not act as a bar or the complainant to state further claim before the concerned or agencies for redressal of argument as this court has not received cancellation.
and Lordship, actually there was no proper verification of this land.
It is also further advised to properly verify and publicly notify before proceeding any land allotment transfer to avoid overlapping of land allotment. There appears to be a overlapping, case of overlapping.
No,
Bombar Dabi was allotted around 1,000.
yes,
Out of 1,252 square meter allotted to petitioner number 2,
two, yes, Lordship,
gifted to her.
yes,
Now rest, you are saying that it is, there are 416 meters,
yes,
square meters, which you have occupied.
yes, Lordship. Petition
And
number
the
one,
ADC found that it is one and the same thing, allotted area of Bombar.
yes, yes.
It could be quite possible.
No, no, no. It's
Then
not
will-
possible because, Your Honor, Your Lordship, that's why I'm trying to establish here that if Your Honor may look into the this passbook of Miss petition number 2, in there I have just described the boundary description. That in the east side there's army place. Your Lordship, in the west side, the 1,000 square meter of petitioner number 3 falls under the west side. But whereas my occupied land is just adjacent to the
No, this has been verified and the statement has been made. The Mandal has made a statement.
Your Lordship, in page number
It's a
31A is the map, which is also
Sir,
surveyed
it's
by
a
the Mandal.
Detailed
Approved by
order.
the,
Sorry,
Your Lordship, this map is also approved by the
it
Deputy
appears to
Commissioner.
be the one and the same within that 1,000.
No, Lordship. If Your Lordship may see the map, it is totally clear, Your Lordship. Kindly come to the page 31A, Your
Which
Lordship.
map?
Page 31A.
Which map?
This map is sketched during while I am applying for the allotment, Your Lordship. Here, Your Lordship can see that in
Number
the
two, you don't have any right until the time it is allotted.
but Your Lordship, in fact, this plot of land doesn't come under the 1,000 square meter,
We don't know.
which is owned by
We will believe the decision, of
Because-
elaborate decision. of
Your Lordship.
the-
Regarding this, I have been
Order-
already issued an NOC also, Your Lordship. I have been issued NOC plus
Who has issued
this,
this?
from the Forest Department, from the DC office, from the Urban Development Office, Your Lordship, Department. And Your Lordship, this map is also drawn by the DLR also, Mandal, Your Lordship, and approved by the Deputy Commissioner. So my submission is that, Your Lordship, more than decade, during the lifetime of the father of the petitioner number 2, there was no any such dispute. But after her demise, then only respondent number 3 is complaining that that particular occupied land comes under their 1,000 total 1,000 square meter plot of land.
You don't want your that 252 square meters to be demarcated.
Your Honor, it is already demarcated. 252 is not in dispute, Your Honor. The disputed land is adjacent to that 252.
Who has demarcated?
Your Lordship, I have
It's not you. You'll be obviously you.
Yes, because
claiming that land it doesn't fall under that.
no,
Against
Your
the
Lordship,
findings of the additional deputy commissioner.
Your Lordship, because 250 is not disputed because, Your Honor, I have a separate allotment
Demarcation.
passbook. Yes, it's made.
Allotment is not disputed, but demarcation is disputed. It has to be demarcated
Your Honor,
because it's not disputed.
Your Honor, the disputed plot of land is different. That is in the different side, Your Lordship. This, let me make it clear in a different way, Your Lordship. Before the gifting,
I'm clear. If you are not clear, I don't know. I'm clear.
yes, Your Lordship. So all I'm saying,
Why I'm clear? Should I tell you?
yes,
You are claiming 416 square meters, which you have claimed to have occupied outside the allotted area
yes, Lordship.
or the land which has been allotted to Bombar Dabi,
Yes,
right?
yes,
The out of 1,000 square meters,
Yes,
252 has been allotted to your wife.
yes,
I mean, respondent number.
yes, yes, Lordship.
There's no dispute.
Yes, no dispute.
But the ADC has found that the plot claimed by the you and the 252 students is falls within the same area, allotted area of Bomba because it's around 200, 1,000 something, right?
Yes.
Now ADC has directed to demarcate this 252, which is clear. Maybe legally, irregularly transferred to you, but then directed to demarcate. And it says observe that the advice that before processing for any allotment or transfer, it has to be properly verified and publicly notified. Right?
Yes.
What's wrong in that?
But I'm saying that, Lordship, this impugn order is part
On
arbitrarily.
the complaint of the respondent, private respondent,
Yes.
it was
Under political pressure,
it was
impugn order has been
what kind of
passed, Your
political
Lordship.
pressure are you?
Yes, Your Lordship, because without verifying the actual fact, Your Lordship, there was no such any demarcation, verification prior to passing of this impugn order, Your Lordship. That's my complaint, Your Lordship. That's my submission, Your Lordship. Because this particular occupied plot of land where RCC building has been already constructed by me in the year 2011, that is in a different site. That doesn't touch that 1,000 square meter plot of land. In a map, it's, if you know, may see once the map, it's totally clear, you know. It's totally in the cornermost side of the plot of 1,000 square meter, you know. Because in between, in the land of petitioner number 3 and the disputed land is falls between the land of plot of land of petition number 2, you know, that is not disputed.
Page 35. The verification conducted along with sector magistrate, DLR so and so, disputed land in between so and so, to measure the actual land possession as per cadastral map during 2000 are personnel of the boundary so and so. During the verification, the following findings were made. There was a verification also. Spot verification.
As this, your honor, this order claims that, but in actual there was no verification, your honor.
Also,
Because your honor, your lordship,
sorry, sir.
I am the occupant of that particular land, your
Notice
lordship.
nothing else.
Without let me giving any opportunity,
It's the
what has been passed.
34 also, there are 3. The so-called notice under so-and-so was issued to Sri Nyatam Gambhir and Sri Margam Dabing Gambhir on 22/1/2025. Written statements submitted by Sri Nyatam Gambhir is taken into record. Hearing conducted on 3/2/25, 24/2/25, 10/3/25, and physical verification of the disputed land was carried out on 2/5/2025. Hearing was conducted. Verification was done. What? I will make a small submission. 1997, private respondent was allotted 1,000 square meters. Out of 1,000, it is claimed that 252 is been gifted. That is not in dispute, this fact. By this impugn order, that has been directed to be demarcated. Yes, out of 1,000, you demarcate 252 for the petitioner. Now, the petitioner's claim is that he is in actual occupation of 419 square meters, 416. So, that claim cannot be in the land of the private respondent. It can be somewhere else in the government, other government, but it has, if it is already in the allotted plot of the private respondent, it cannot be allowed, even though he claims to be in occupation. And the finding is that his occupation is on the plot which has already been allotted to the private respondent.
No, your lordship. That's why I'm trying to make submission here. My occupied plot of land is totally different, separated from that particular allotted land. It doesn't fall under the 1,000 allotted square meter land.
That is your.
That is totally in a
And
different
then
one.
the ADC on verification.
Yes, it doesn't fall under that.
So-called notice to you,
Yes.
right?
Yes, Lordship.
After consideration of your reply
Yes, Lordship.
and the verification, caused the verification by the officials of the land management department, found that the land claimed by you and the land allotted to the private respondent falls under one and the same.
No, Your Lordship.
If it is does not
Because, Your
fall,
Lordship,
my lord,
that-
what I'll submit, if it does not fall in the same plot, let the demarcation be done. Let it 252 be carved out from 1000. The remaining, let it remain with the private respondent. He may claim the 416 square meter elsewhere. That's all. If he claims that it is not, it does not fall within the allotted plot of the private respondent.
Are you agreeable?
No, because Your Lordship, because
See, he
That's
is
why-
correct.
that's
See,
why I'm submitting, Your
let us,
Lordship.
let us accept your submission.
And if I may, Lordship,
Let us accept your submission
yes,
that this 416 falls outside the 1000
yes, yes, Lordship.
square meter
Yes, Lordship.
allotted to private respondent.
Yes, Lordship.
Now, we'll allow to go for demarcation to demarcate 252 out of 1000. All right.
Yes.
And
May I, Lordship?
if your 416 falls outside the 1000 square meters, then authority will consider for allotment. But if it falls within 1000 kilometers, square meters,
Yes, Lordship.
you have to,
Yeah, may I,
you
Lordship?
have to
Actually,
surrender
actually-
your occupation.
actually, Lordship, that cannot,
That would be
No, no,
would be the
because-
best way out.
may I, there's one more thing, Your Lordship.
Yes.
Because out of that 1000 square meter, 252 is gifted to the allotted to the respondent number petitioner number 2.
Yes.
And even some portion of the land was out of that 1000 has been sold to the other people also. Your Lordship. So it
Has it been sold?
because
to you?
it cannot be
Has it been sold to you? It has not been sold to you.
not sold to me, but to the some
Your
other person.
claim is that it falls outside the
1000.
1000.
Yes, yes,
We'll make it clear.
yes.
Let them have a
Because
demarcation.
the sold land
Let there be a
calculated under that
Sir,
1000.
let there be a demarcation. First, this, as per this order, let there be a demarcation of the 252. And there, and to verify whether 416 falls under 1000 allotted square meter.
Yes, Lord. So because
If it falls under, then you have to surrender your occupation. If it is outside the that 1000, then authority may consider for an.
because yes,
That's
Your
all.
Honor, in
There
here,
will be a way out.
yes, Your Lordship. But in here also, state officer has excluded the portion of land which has been sold by the late Bomar Dabi, which falls under the allotted land 1000. So to make that up, they are including my plot of land, which is not a part of 1000 square meter. That's the problem here. Because if, as per Your Lordship said, if there will be a demarcation,
Yes.
then the sole portion of land should be calculated under that 1000 square meter.
Chief, I have received this petition today morning and leading counsel is out of station. And if this petition is admitted, otherwise this, okay. Okay, if then disposed, it may be disposed today. I will rely upon submission made by petitioner number 1 or additional AG. That is, sorry,
Respondent.
respondent number 1. No,
He's saying
Yes, Your Lordship.
if you short form
Yes.
to help you out, they have to try.
uh,
Anything against the authority?
Authority is in his favor.
Obviously, it's-
Yes. Yes. Due to some political pressure, that's why
He's right.
they are favoring her, Your Lordship. The respondent number 2, favoring the
Then
respondent
we
number
issue
3.
notice,
Yes, Lordship.
no point. Or Mr.
T. Pumbo, Your Lordship.
learned counsel for the petitioner. Petitioners. Challenge made in this. Passed by the. Additional Deputy Commissioner, Kami State of Weber. Then allotted petition number 2 for transfer from late Muhammad Nabi, husband of respondent number
3.
respondent number 3. And the land claim and freshly applied for allotment by the petitioner number 1 is the same plot of land adjacent to RB Exchange Company. Thereby directed Land Management Department to demarcate the allotted plot of petition number 2. Measuring. As per allotted map. And advanced properly verified public. Measuring 416 square meters. At where?
At
Yes.
Siam Colony.
It's your colony. For which for which the prison number 1 has applied for allotment. So, the then occupied by petitioner measuring 460 square meter is outside the allotted area, allotted area to let one Muhammad Nabi, one let them Muhammad Nabi, which is around 1,000 square meters. It is completed. It is strong with helping the let by the same plot of them change the allotted not them.
Stick this one, so I.
Do you know, state is represented by not less than the secretary of the state.
Yes, it's good, sir.
Then. Anyway, you take over, I will not look at this stage, take over it. Since the respondents are represented by the state. And the additional duty general. And MS Viva
Aaron.
for respondent of change. And not for the What is the say you maintain status quo,
Malala,
you're unable then, but then we'll direct them to go for demarcation.
the issue on the maintainability of the writ petition may also be kept open because in fact, the original order of the ADC, they have to file an appeal for the deputy commissioner.
As Mr. Advocate Mohammed has raised that sensitivity of the definition on the ground that there is a appeal provision under the rule.
The act. For this, then record.
No. Provisions of what?
For this, then record and settlement.
Then settlement. Act 2000.
2000.
And the and the state is not represented by the secretary to the state. The same shall be considered on the next date, next period. Having considered the submissions of the council, what is so considering that the petitioner claims to have occupied a land measuring 416 square meter outside the allotted area of 1,000 square meters. This
Part the impugn order.
No, Your Lordship, because in impeachment it says that there should be a geotag also. So,
why you can stop that?
Your Lordship,
Why you can stop that? In terms of the order dated
because
11/7/2025. Passed by the ADC Cup State Officer,
Your Lordship,
Western District.
till the disposal of this petition, Your Honor, there should be no geotag. There should not.
Why you cannot, there cannot be geotech?
Because Your Lordship, in para 10 also I have mentioned that.
Where, if you are ready, maintain the status quo.
Yes, yes,
So you are not before. But at the same time, we'll go for the demarcation.
yes, I'm not against it.
Then in that case, it will be more clear
Democracy should be done.
who is lying.
Yes, Lordship. Yes. But Lordship, they must include the plot of land that I have mentioned in para 10 also. Your Lordship, in para 10, I have mentioned that they have, out of 1,000, they have sold some portion of the land to the some other party. That should have already, must also come under that demarcation, Your Lordship.
Simply a demarcation.
All I'm concerned is, Your Lordship, that particular plot of land should also include under that 1,000, which was sold by the late Bomar Dabi. In the para 10, I have mentioned in para 10. Because they are not including that land and they are including my land. They have already sold some portion of land from 1,000.
Obliged.
What's wrong? Wrong is that Lordship, it is a frequent transfer. I'm a victim of transfer. Why victim? Yes.
Kindly see Lordship.
Your service as a teacher is required. No? Yes.
There is a, for administrative conveniences, Lordship, balance has to be maintained, Lordship. To balance the transfer and posting, there is a guidelines, Lordship.
They are comprehensive of transfer. We'll say implement.
appeal order is lordship, kindly see page number,
It's not only you, four pictures have been transferred.
that is there, but this is a premature transfer. But in terms of guidelines, lordship. Because lordship, as per the education
If I
rule,
correctly remember, education
Rule,
very
lordship.
fixed.
as per the education rule, lordship, may I draw the attention? Education rules 2010, rule 55 of sub of A. Transfer should not be made in the mid of the academic session, and it should be considered exceptional case only during this mid of the academic session. This is the extent of the department. That is what rule say. And above all, here is a guidelines. That is a 2 year. And it is not a matter of this year, Lordship. It should be
Last
guided by the rule.
When transfer when?
Lordship, kindly my this page number, kindly see page number 19.
17 is
19
from residency school permit to witness
Yeah.
two,
here.
21, 22.
Yeah.
21, 22. Then
18, page number 18, 19, then 20, this, kindly see page number 19 is there, and I have current plate. 20 December 2023, I at Subla.
April transfer was made.
Yes, not,
And release 29,
release were done on 19 December.
29.
Yes, no, page number 19, election number 3.
Election number 2.
Kindly see, election number 2 is another transfer order, the previous transfer order. That is the April 21, 2022. I was from it's a residential school, Pame, to Yingku. And then Yingku from in the 2022 again in the same year, another year, from Yingku to Suble. And now from Suble to Bole. It's a lordship, generally in such cases, lordship, regions has to be recorded. Lordship. There should be a regions.
Initially, there was 0 enrollment.
That is another, even then I was transferred, that is not my fault.
Huh?
That is not, none of my fault, because I was
Permit,
transferred.
there was zero enrollment.
Not Pame lordship. It was not in case of Pame, it was a zero enrollment case at Yingku.
Huh?
At Yingku. Kindly,
Okay.
Yingku.
You were
Then
transferred
Yingku,
to
from Yingku to, there was in Yingku, there was zero enrollment when I have joined there. In the next academic,
If there was
next
no,
academic,
if there was zero enrollment, you were transferred to.
again and Shukla,
Ah,
the next year.
okay.
Then within this, this period, within this restricted period, I have been again transferred to Bolang.
So, how far it is?
It is about 20 kilometers. 20 kilometers in the village area. It is a part town area. Sorry. Lordship, this is a family hardship matter, Lord. That cannot be, that the transfer cannot be based on Nigeria, Lord. It should be guided by activity department. Since education rule is there and here, the Procedural Department notification is there, saying that it should be within 2 years. It is the stationary, it is the period of posting in a particular station. In that, within that period, if there is a requirement, it should be exigency as per the exigency of government services. That has to be region. But in this instant case, the authority has issued a transfer to accommodate the private school. That cannot be done. There is a the state, the model employer. That cannot, it, that's manner or transfer cannot be affected. Lord. Transfer and posting should be guided. Lord.
Madam, this, internal order, madam, it is the internal arrangement within the district only. There's no much, in fact, the hardship, madam, this is within, it's in the, for the convenience of the student only. This has been, this something has been done. It's internal arrangement. Madam. And there's no any,
You have joined in December. 19 December you were released. And more than 20.
15 December, 15 December. 15 December. Now
Almost
I
2
have
years.
I have been transferred on
Almost 2 years.
August. It's yet to be December. It is September, it is October, November, second December.
Yes.
Otherwise, guidelines is meaningless. Rule has to be administrative.
Not this time. Demo.
Tapak.
Tapak. Not concentrated. Condition. Cannot make if the convincing, then just one aid condition, Mr. Tagum, the land council further submits contains that the transfer order has been issued to only to accommodate the private respondent. Then you write notes. Then it is no. Observation already made, man.
Matter that dispose of direct. There is no interim order.
Well, you have that private disclosure.
Lordship, my allegation is that to accommodate that person.
We try to fight for grant to, but
Matter that it is possible.
give me private disclosure.
Serve no purpose. Serve no purpose. Let the matter be.
Here is no purpose. Employee, not when it is.
Ultimately, on merit, if material is brought against, man, ultimately it can
my-
interfere, man,
My
no issue.
question that as per the 55, 2010, transfer cannot be generated without the academic. That is
We'll consider.
And this is, no regions has been recorded, and this has been issued in the middle because it has been a common pattern. That is the, this is the one purpose, because there is the-
You add one more is contention. No region has been recorded in the transfer.
Yes.
Transfer. Then you, in my view, you said, and law doesn't require to give reasons in the order. You add that.
Not if you have lordship, in that case, in case of no interim relief lordship, it will be the lordship. Lordship, this is a rural area. Rural area. Shukla is a rural. I am ready to serve. I am serving not that. I cannot go to Bolling. Bolling is a better place.
Item number 3,
Notice cannot stop the construction. 4 lane.
No, no, matter,
4 lane construction.
matter,
Well, issue notice, obviously,
matter.
you cannot stay the construction. Construction we cannot.
No matter, in other matter, development is matter.
It's a construction of a road, 4 lane.
Yes, matter, but it cannot be my violation of the human rights.
Obviously, we'll consider that. You are not saying that you don't want to part with the land. You'll be happy with the compensation.
Yes, sir.
We'll consider that.
Yes, man, it is the one
Whether
aspect.
it has been properly acquired or not, we'll see.
That is one aspect of the matter.
Ultimately, you want the compensation.
Matter what they are doing, matter, they are saying that matter, the existing matter, the DPL, existing road matter, it's for 45 meter matter. Now they are matter only acquiring matter, they are not acquiring the land matter. They are giving only matter, assessing matter, the assets matter. And they are saying that matter, the.
Only the compensation is on assets only. We'll see. We'll let them fight. Let them come back.
Educating matter, at no point of time, the present road matter,
Yes,
the double lane road matter,
4 lane.
no, double lane road, existing road matter. Okay. Or Upsing to iron matter was never acquired matter. Now they are saying that matter, the 45 meter is a matter existing right of way matter. Without any acquisition matter, now they are saying that matter 40 up to 45 meter matter, the existing right of way matter. That's why they will not acquire those land. That's why I am challenging the entire matter of acquisition portion. That okay. That is, Feroz for a moment, my lord.
When they prevent not.
Yes, my lord. 65, my lord.
2409,
Yes, man.
64,
65, my lord.
68.
68, my lord. One of the right. Yeah.
September, October.
Section 12 says, my lord.
November, please 79. Have you received, are you a part of this? Have you filed the claims and objection?
Yes, my lord.
Wait, what,
My lord, before coming to that, my lord.
when does your, when it, what that appears? Page 79.
My lord, yes, my lord, my name later, my lord. Someone will- Yes, my lord.
Not all the petitioners.
My lord,
Have they filed their objection?
no, finally you have filed the objection, my lord. It pays 92, my lord. So before that, may I object the case, my lord? Before completion of the matter process, they have prescribed the section 12 and the 20 for survey of the land and verification of the land. The section 21 notice was passed, issued by the due to completion of the matter 30 days matter objection time is required by the matter section 11 matter. There, matter, instead of doing that matter, they have matter the section 12 proceeding has been followed only after matter passing of the matter section of the section 21 of the constitution of the board matter. This ought to have been matter done first matter. Thereafter, section 21 notice has to be given. The board was constituted matter on 6/12/2024 matter. Date 81. Whatever information of the whole conduct method, right?
Final basis. Addendum.
Yes, sir.
Notification.
No minor assessment and survey has been done till date matter. Despite that matter, section notice was, section 21 notice was issued.
Again,
Not again matter, prior to that matter. prior to the constitution of the court matter for assessment, section 21.
It's okay, now they have addendum preliminary, what does it
Additional requirement of minor 1.99.
additional requirement?
Additional requirement of some requirement. 1.09.
So these are, this 1.01 hectare is your land.
Yes, madam. It also- Now, basically what they are saying, my lord, the assessment has not been done till date, my lord. Basically, they are saying that, my lord, the 45, my lord, meter, my lord, and in the, my lord, built-up area, 30 meter, they are all already, my lord, acquired lands, my lord. They are saying, my lord.
Acquired land.
Yes, existing, my lord, right of way, my lord. And which was never acquired, my lord, while constructing the, my lord, the present full line, my lord. It was constructed in the year 2009, my lord. And for which, my lord, we have filed an RTA application before the, my lord, the authority, my lord, seeking information, my lord, whether the land was acquired or not, my lord. And before that, my lord, case 100, my lord. Case 103, my lord. By the, my lord, officer commanding, my lord, grave the, my lord, deputy commissioner, my lord. Type copy at page 104, my lord. For constructing the double line, my lord, present double line, my lord, the grave has, my lord, requested the, my lord, deputy commissioner, my lord. Subject, my lord, acquisition of land and compensation. Of inspector for double making of the
Into then what is this present acquisition, preliminary notification?
same status of the road, my lord.
It's 2000. That's where 2024.
Now this is for four-lane matter.
Hmm.
Even for the matter two-lane matter, there is no acquisition proceeding matter. Now they are acquiring matter and for constructing four-lane. Now the four-lane matter required for constructing four-lane required matter, 45 meter for the central lane matter. Lane matter, and 30 meter in front of the middle. Now they are saying matter, the existing 45 meter is matter the existing right of way. My contention is that matter, at no point of time, so the double laning was also acquired. The question of existing right of way of 45 meters. doesn't matter. Now, if they want to construct the lane, road matter, four-lane road matter, they have to acquire the lane.
That's where they are acquiring.
Not they are acquiring. Matter.
Two lane, it's over.
Over matter.
Gone. 2006, 2000, so we're 20 years back.
Matter. They are not.
Now they are acquiring the four lane. You may have a claim on that,
Matter.
not the two lane.
Matter. They are not acquiring that lane matter. They are acquiring my lord.
According to you, they are just paying they are just extending its which appears to have already been acquired, and they are just paying the assets on the land.
Yes, yes. Yes.
Then we'll see, we'll examine it.
So,
Let-
my lord,
Let there be a four lane. Looks him to where?
no, my lord, it's a matter under the project, my lord. Another matter, my lord. That's the government of India, my lord. From taking point is that my lord Margaret, and it will finish at ON.
Yes.
So, Akagan.
So let them construct. Ultimately, you cannot object it if it is required. If it's not acquired and if your land is not being paid, you'll be paid compensation. In accordance with the law.
My lord, they will not acquire the land, my lord. That's why we are telling.
That's why we'll examine it. Why they are not acquired. But interim, it's very difficult to, hold the project construction. We'll examine it.
Data matter, development, board, matter. Here it's a matter, question of matter, land acquisition matter. My lands are being required matter. Required matter. Without any compensation. Question of the agreement and the.
It's okay. Consider that. We'll examine them. Cannot wait. Yes.
My lord, I'll appear for 1 and 2, my lord. My lord, we'll have to see whether the earlier 2 lane that has already been constructed, whether the right of way, it is already 30 meters or 45 meters.
No, that's why
Now-
I thought that
yes,
the
madam.
earlier reply saying that there is no record.
Yes, there is no record, but however, if they have not claimed at that point of time when the double lane was already constructed, can now they claim as a matter of right that this does not fall under the ROW because there is no notification to that effect. In earlier acquisition process where the construction was already carried out, they have not objected to that. The double lane has already been constructed. Now it's only widening. And the widening was,
107, available records in the office. But
Yes.
Notification letter of office commanding correspondent.
yes, my lord.
These are the letters you have on. These are the letters you have. Where is that notification?
Notification I see, it's another place, right? It's one of eight matter. Regarding him, the man, matter, second paragraph matter, single from a second paragraph. Whereas the amount of required to be acquired by the consent as public. Constructor post road. It's a approach road matter. By road to the board rating of the order, Bharat Mother. Rating of the. For the step road. It's altogether different language. That is also matter of the 2001 matter.
my lord, I'm not,
The requisitions on my
What made thereupon and the list of project approved minutes not formed.
my lord, no, my lord, my submission is that it is not a dispute that there is already an existing two lane. That existing two lane was constructed way back in 2006 or prior to that. Now, during that construction of the two lane, these petitioners, whether they have made any claims or objections on that. And while constructing that two lane, double lane, already it has been earmarked, my lord has seen that not only the lane, but the periphery of that, boundaries of that double lane.
So that's what they're saying is there's no record to show that this
Yes, my
land
lord.
has been acquired.
Yes, my lord. That's why.
Because they acquired, you cannot defraud them. Only what you have acquired and sought to be, they are sought to be paid in the assets on the land.
Yes.
But the presumption that without there being acquisition, it has already been acquired. It's only right of way.
Yes, my lord. Already in the earlier project, already there has been created a right of way, which they did not object to that at that point of time. What
Are
I'm
you
saying-
saying there was I mean, it's not,
Even if-
they have not objected, although there was no acquisition.
My lord, the fact remains that yes, the fact remains that it has been constructed already. Exist.
Doesn't matter.
Whether they have objected, they have not shown anything that they have.
Some Santi Devi or Sila,
They have not objected and they have not shown anything.
state of Himachal Pradesh,
They have not objected. They have already
even if 60
admitted.
60 years, 100 years, if it's a land, a private land belongs to the citizen, if you have not acquired, you have to acquire it, you have to pay compensation.
Yes, my lord. Now, my lord.
There's
Now, ultimately, what?
no question of this.
Yes, ultimately, whether that was acquired, not acquired, ultimately it will boil down to the fact that compensation, adequate compensation, including this 30 meters or 45 meters, the assets. Who will determine that? That will be determined by the authority.
Therefore, what they are saying is,
The
without there
reference,
being an acquisition, you are just issuing a preliminary notification that to violating the provisions of the 2013 Act and only for the payment of assets of the standing on the ROW. Unless you acquire that land, there's a question of the ROW. First, you have to acquire that land and you have to pay for that land compensation. Then only the widening and all these things, the assets can be.
yes, my lord. That's why, my lord, I'll put it in the other way. When there is already an existing ROW,
There's no dispute.
yes, my lord. Whether now,
But what they're saying is, you have not acquired the land at all.
yes,
So
my
you
lord.
have constructed
Yes,
the two
But-
land.
that
double
means
land.
they are admitting that there is
Just because there is an existing double land, there cannot be ROW unless the land is been acquired and paid compensation.
yes, my lord. In that event, that's why I was submitting when they have not claimed in the first instance when the ROW was created. How can now they claim that there is no ROW? In any case, my lord may issue notice.
Anyway, sir, I have understood. We'll issue notice. We'll consider all your grievances. Let them file their.
Yes.
Are you the But how many petitioners? 47 are only the owners. There's no others landowner.
Yeah, maybe one, we are 47 again.
Heard Mr. Arsake, learn counsel to the petitioners. Next parent. The petitioners, number 47 in numbers, claims to be the landowners have challenged the land acquisition proceedings, including the preliminary notification dated 24/09/2024, issued under section 11 of the Right to Fair Compensation and Transparency and Land Acquisition Rehabilitation Resettlement Act 2013. For acquisition of land measuring 1.99 HAI hectares for proposed widening of the improvement of four lane with paved soldier from kilometer 55 plus 000 to kilometer 82 plus 514 of National Highway 515 at Oyan, Asiang District, Arunachal Pradesh. Mr. It is the next para. Contended that the respondent authorities have illegally illegally claiming that the existing right of way within bracket ROW bracket of NS 515 double lane road at Oyan area as 30 meters in built up area and 45 meters in open area. As no point of time the land of the petitioners have been acquired by the authorities. It is the further contention. So the authorities have issued a notification under section 21. Notification, where is that? It's a 21 notification. Yes, that is preliminary notification. That we have said so. Then you said before expiry of 30 days.
Yes, public notice,
Okay.
in 77.
It is contended that the public notice under section 21 of so and so, we did it. On top you write in short LARR Act. Before the expiry of 30 days, which is required under the provisions of the law. Mr.
And also by the
Completion of the completing the procedure required to be followed under section 12 and 21. 12 and 20 of the said act. Mr. It is further contended that the land sought to be, that the compensation sought to be paid is only for the assets. Assets standing allegedly on the right of way. Whereas no acquisition even for the double land has been, no land has, the land has not been acquired even for construction of existing double land. That's all. Should notice returnable by 4 weeks.
I don't like to say, madam, that the last matter verification to be done. By our same, madam. And madam, now work has been started, madam. The asset cannot be madam disturbed. The work may carry out in the open area, madam. The asset should not be madam disturbed. No,
We'll make it 3 weeks. Let us see. That will amount to, put hurdles on the construction.
Yes.
Particularly this
the open area.
I agree with you. I understand that it's only in the tender matter. But it is, construction is also for the public interest. Therefore, once it has already been started, when this court particularly lot to declare. But ultimately, there would not be any occasion to hand over your land back to you if they don't want to pay compensation. That cannot be done. Ultimately, things will be, you will be adequately compensated. If there is no acquisition, it has to be acquired.
Yes.
That will be done. Let the, board constructed for the public interest. We'll consider it matter. Prima facie, it appears that there is no acquisition. Definitely,
May I pray that, madam?
the Supreme Court is very clear.
Another Indian prayer that, no, madam, final amount. So the assessment has not been done, madam.
Final about whether their lands are also
I will not
included.
say anything
Yes.
now. There is no, let us not say anything now because let them come. Let them file their affidavit. Final award, no award, if we find that the land has not been acquired at all. And they have not followed the procedure, right? Then we'll definitely different.
From the final award, only,
Because that will be a notice if they have not followed the provisions in acquiring or passing the award. That will be notice. That's why we have recorded submission. It's better to keep quiet. But
highly open.
They will, madam, wash out, madam, our assets, madam.
Survey is already, verification is already going on.
No, no.
Here it goes.
Please, madam, 24. Yes, the assessment of the exemption.
in that case, say no final award, but then make it clear that construction.
Madam, from the final award only will be able to make out whether their land has been compensated or not.
For the assessment.
Pilot may observe that
What assets are there? Definitely,
yes,
they'll not be subtracted. Your welfare is there, and they're taking your land also. They cannot. No, that.
yes, yes. Now,
Well, he's madam.
The court and particularly on Supreme Court is not heavy on the legal justice, so-called legal justice.
yes, madam. Without recording the assets, it won't be destroyed, madam.
Statement will be from court.
That without recording the assets, that assets will not be destroyed. dismantled.
Recording the
Yeah, assets. Without recording the assets, which has to be dismantled, that will never be dismantled, madam. How can anyone dismantle?
Then we'll see next
Yes.
date. Okay. Will let us have a faith on.
That's why my respectful submission, his statement may be recorded. That's why.
But sir, if you have a faith on him. So,
Sometimes I have great faith on.
okay.
Item number 6.
Yes. Step 6.
We have filed out counter affidavit, Your Lordship.
Who is respondent number 1?
Additional Deputy Commissioner, Your Lordship.
ADC.
We have filed, Your Lordship.
It has been filed already. I have not received that. Okay. I don't. I have.
Sir, Your Lordship.
What is the matter?
Disputed land matter, Your Lordship.
What is your state? What is your jurisdiction? Where is the authority to decide the title now?
Your Lordship, in this matter, Your Lordship, ADC has not given the judgment order in this matter, only uphold the decision of the Gaba, Your Lordship. And Your Lordship, this is claiming over the ownership of the disputed land, Your Lordship. Then Your
Okay,
Lordship may
okay.
dispose of the matter, Your Lordship.
How can he appeal the decision of the Keba unless he is not an appellate or the authority?
ADC has simply declared, Your Lordship.
It is submitted
Unless
by, you furnish a copy to him. Therefore, respondent. What do you say? What do you say? What is your state? Can ADC decide now? So in that. Under what provision? 145. So can you decide the title under 145 proceedings? Yes. Title has already been decided by the Quebec. Then it's. Have you filed an appeal? He has not decided the title. He has just observed that the title has already been decided by the Keba.
I'll Rejoinder, my lord.
Let them serve. Why, if the FDC has not decided the title, you can say 140, 145, what's wrong there? There can be there can be an observation, what's wrong there?
There is some subsequent that I need to file additional.
It is submitted by Mr. L. Nasir, learned counsel for the petitioner, that he has not been furnished with a copy of the affidavit of position filed on behalf of the respondent number 1, to which MSP Pango Lagna State Council assures to furnish a copy. We of that is naturally listed after 3 weeks. Have been there. Yes, the state council. Mr. Ebodo.
Item number 7.
Yes. Completion period.
Yes,
One, out of time.
my lord,
Only the protection my lord is given is subjectively out. Okay. So that's why my lord, that observation has been made by this honorable court, my lord. That's why if my lord wants to dispose this matter on merits, then I will ask. But only on the point, because construction they have carried out during the. No, I just wanted. Just wanted to know. Fine. Then my lord, yes, are you ready? Pleadings are complete.
yes, yes.
Are you ready?
So if my lord want to hear, then let the matter be admitted and fixed for hearing.
This matter can be disposed of, my lord. Otherwise,
Otherwise, nothing remains.
my lord, one defect, my lord, they are citing, which I also admit, madam.
Yes.
My, the defect, madam, which they are. Then in one other defect I have denied, and they don't have any material. But one of the defect in my technical was that one water mount tanker, two numbers of water tanker had to be submitted. So I hired on these vehicle, but the registration given to register this registration certificate registration given to me was shown that this is a water mount tank. So I submit. So later on through the affidavit, I came to know that this is not a water mount. This registration is wrong. But so we then I inquired from the person from which this was taken on lease. Then that defect, my lord, I also had. But still the question remains, my lord. This defect, my lord, It reminds me that in the BDS carriers contractor, the registration, I mean, the scooter was hoped to have carried this is not my document, my lord. And on good faith, my lord, I was given the registration I used. That is, and now the question is still different. This
Whereas
part,
this is defect in substantial nature or
my lord, and question, my lord, whether if this defect, whether I should have been given the chance, number one, considering my all this experience, all this, my lord. Second, the effects of the private respondent are more serious in nature. More serious.
no, first you clear your hurdles.
But my hurdles is only this much, man. Nothing but. Now all those other saying that I am having
And
other
it can be a ground for rejection or technical break.
my,
Let us be very fair.
my
If you concede, this could be a ground for rejection of technical matter instead. Let them construct, but
on that point, Madam, is still my point, Madam. My basic private submissions, my this defect is non-essential.
not essential, not substantial.
But when the respondent authority can accommodate the private respondent whose defects are more substantive in the essential part, but that discretion that could have been extended on my non-essential part, but that is so that malafide intention accommodate. So otherwise, had I been given that chance to at least produce to vehicle on it,
Suppose if your writ petition is allowed. What can we, what it can be done? I know.
that is part of my lord. I leave it to code only because my lord.
That will have to be very
Yes, my lord.
clear about it.
Yes, my lord.
Suppose if it is found that your case is not happy, your technical thing ought not to have it. Find that the private respondent has been
But whenever my subject to the outcome, whenever this protection is given, my understanding of that
what substantive relief is provided. Suppose if you are writ petition, we accept that. And
then it's very difficult even for me to ask directly, my lord. I leave it the wisdom of this sort of a book, my lord.
otherwise, because it did not be a kind of
That subject to the outcome.
law called adjournment. Adjournment is also not possible. Correct. So we may provide you to go for compensation, compensation.
I understand. Of the prayer also that is there. There is a proceed that holds prayer too.
Let's see the first rejection. Technical bit. Your case.
One at a time. Each meeting must demonstrate. But only registration of yes, but
Availability for construction work of technical use.
I have all these fellow with certificates, all those things I have submitted, even the respondent are not going to submit that one.
Okay, then
Now, 4.71. SPD and 4.71. And to find misleading. I have made this was not deliberately melon because I hired the vehicle from the other person. And I was given the registration of a drug mounted registration. Sorry. I submitted, and after getting objection, I inquired from the registration of this DTO. Then I was told, no, this is a dumper.
you have given it for this thing,
Drug mounted.
drug market.
Tank.
water tank. But it is found that this registration are of the deeper. It's subsequently actually. These are the grounds, my lord. My lord, as seen in the technical 3 clauses, these are the grounds. Now, so far, one part is concerned, I concede to the definition. Misleading and other technical person, my lord, there's nothing on the record to reject my paper. So, thereafter, my lord, now what are the effects of my lord? Respondent. No, my lord. As per the NIT or the terms of the candidate, my lord, SPD. S should be applied very clearly on my. Okay, what's the defect of R5? My lord, respondent number 5, my lord. First, my lord. First, so far, my lord, this bank certificate had been treated publicly. Now, of course, respondent 5 and they are denying this certificate was not submitted, but they have submitted different. But this certificate basically I downloaded from the website. Because it has to be put on the online website. From there, otherwise I don't have any access. So here, my lord, if you see, it is in annexure 6, my lord. Page. Next, sir. Yes. This was uploaded, but the contract work is in respect of something what from Dirang to Jimthung Lang so and so, not for this particular project. But now they have come with the affidavit and response saying that they have submitted another bank certificate. And this itself, my lord, but this was there in the on the this portal. This is for different project. But they are now, they have come with some certain different certificate. What can we do? My lord, this could be, I could obtain from the portal, I obtain it and I put. Now from where they are bringing this? They say that, yes, this was submitted, but then we have accepted later on other one. Are they accepting it? No. This is how they have brought on record that they have submitted another bank set. Now it is on the respondent authority. Now, second part, madam. This part, government is also. Even if it is there, but that is the other certificate issued by the SBI. Cannot be, the development is, a mistake, cannot be essential kind of condition. It is only, they have to take a by the airport for the particular. They have that. Government wants to do big, no question. So next matter, next matter. There. What affidavit has been saved with them. Now, but which they are not denying, the justification for the government is that since it has been given together in the same week, so it has to be inferred that this affidavit is for this particular project. So there is final bit 5 annexure 7. Madam. But here, no name of the project scope has been mentioned. Just given the this thing. This affidavit. This is also, but they are denying, they are saying that we have inferred this project, that's why we have accepted. This is what wrong. Another following wrong was it's the according to you, the requirement is to mention the name of the project. This is one of the grounds. Another matter. No, where does the requirement from this? This so far, madam, this investment of case, also I have found in SBD, madam. Affidavit. Yes, I have not found in SBD also that one. Huh? Let's go. This affidavit is not, I mean, given it is to be provided in the SBD. It is this part portion I have not found in SBD also, this part. Madam. Then, my lord, what, another, now, two more defects, madam. Eight more defects are this for us. One is the undertaking. No, madam. This, it is where it is. Fine. F cost 4.6 of there. 4.6 loss of the FPD. But generally, one interesting question, madam. Suppose a bidder is participating in tender. Then the question comes, yes, he exercise and he comes out to be, my lord, findings, whether he is his bid capacity, whether he fulfills the bid capacity or not. Because there is the bid capacity is there to participate in each bid. Now here is the case. Now what they have done is only they have submitted document, they have said. Now, but they don't know about themselves whether they have that requisite bid capacity to participate in the tender process. Now what their state is that now this will be prepared by the respondent author. Now this is very surprising. You don't know your own capacity. Now you are participating in a tender process. But generally what generally the tender process is there, what the bidder does is he make up own bidding capacity. Calculate. Thereafter he submits that capacity. Thereafter, my respondent author evaluate and make the verification whether the bid capacity is submitted by the tenderer, supported by the document, supported by the materials or not. Here is the case. Bidders have said that this is the job of the respondent authority. And many cases, my lord, even the respondent authority does not come with the affidavit what is their bidding capacity. When I have specifically raise this issue in the respondent of state come with the what is their bidding, and it's completely silence on that part.
What is your bidding capacity?
My lord, my bidding capacity, I have, my lord, submitted in the manner, my lord, will find at my reply, my lord. Kindly turn to my affidavit reply. Is the my lord, they have not, my lord, they have not submitted bid capacity. Now, what they have done is only they are saying, even my lord, so far as is concerned, even he has not submitted in 5 years of the work he has carried out. And these details of 5 years work have to be given. Now, how the bid will be calculated?
Respondent number 5 or 6?
6, my lord. And respondent number 5 also not submitted.
Who has been awarded?
Respondent number 5.
What person was?
Yes, but
Okay, number
why I am saying, my lord, that because still I am the technical stage, man. Because respondent 6, my lord, there were glaring major defects in respondent number 6, my lord.
Ultimately, we have.
Were again allowed, man. Then, my lord,
That will be academic again.
had I been allowed, my lord, definitely,
You
my
have concentrated on 5.
fine.
Who has been awarded?
Then, my lord, this 5, my lord, not submitted because he is saying that I have submitted a document. And it has not come on the record, what is the difference? Last Sure. All B holders.
B holder. And B holder no experience, yes, they in charge.
No experience.
They, from their experience, I will take to their affidavit.
Affidavit. They be- If they have the knowledge of this, live and live. Live,
Yes, they in charge, lab technician, but
they can have the, can they have this knowledge of this, testing and all those things?
if my submission. Of course, theoretical you may have, because B, but here is the question, my lord. Certain experience is being asked, my lord. Now you need to have experience, my lord. Otherwise,
Why should one ask the experience? Directly one can say, okay, this degree is enough. But that's why, my lord, that's why, my lord, so far, why, I can't.
What about you?
My lord, experience. Of course, my also BE civil, but I have experience.
Have the same site engineer.
No,
Experience.
as a lab technician, as a lab in charge. But
But they cannot be disqualified from being a lab assistant or a lab technician. Laboratory in charge or a lab technician.
so far, technician, my understanding,
They will have the knowledge.
they have the theoretical. But since the NIT is saying that you need to have a experience,
Although in affidavit they say this must be experience, but their individual
As a
affidavit
site
they say
engineer.
site engineer.
not, they never work as a lab technician, lab in charge.
They didn't say that. They didn't say that they are the site engineer. Site engineer could include also lab technician. If they have
What is their affidavit is that? Now we want to propose it to work as a lab in charge. Earlier, they were engaged as a site engineer. Now this is their contention, my lord. Now we would like to engage them onwards as a lab technician. This is their specific contention, my lord.
otherwise it's a false affidavit.
That's why, my lord.
Misleading.
Yes, my lord, misleading. That's why, my lord, but respondent authority is, my lord, more harsh towards me and has a some soft corner for my lord, respondent number 5. So that's where, my lord, I am saying that Article 14 comes when you are having some soft corner for somebody and hard corner for somebody. This is my case basically. Otherwise, my lord, my defect comparatively is very minor. And I am a, my lord, class 1 AAA contractor, my lord. This definitely I could have managed, my lord, provided I asked, my lord.
Yes.
Thereafter, my lord, my these are the my lord, basic people from the respondent file systems. These are the one of these. My lord, I see my lord for responses. If my lord goes through my lord, of course, financing. Award. Was made
This is the big capacity part. This is how I calculate and I submit. This is what the responsible five what we have done also. You have to record. Is it there? Have you submitted this? Yes, sir. No, no, I have-
No, my lord, that will answer it.
That's why they're saying that he submitted document only. Calculation.
Okay, so according to you, you have submitted the.
5 years turnovers from that.
The respondents are also have the same kind of bid.
And I have raised that they have not submitted. As on today, even the authority has not come with the affidavit. What is their big capacity?
Let's see.
That's all. That's all.
Any judgment,
Judgment, my lord. I have, my lord.
only one.
Only one 2024 items.
Yes, just give the citation. What's the citation?
Citation, my lord. 24. In is 7
273. Page,
page, my lord.
sorry, para.
My lord, there are pages. My lord, right. All earlier judgments that we have discussed. This case, madam, basically, in this case, what happened, madam? Of course, execution was not done, but agreement was done. The apex court said that even though agreement might have been done, but the manner in which the technical bid was disqualified, there was a malafide and arbitrary excessive power, and therefore, my lord, this direction was passed to consider the fresh, consider the technical.
there is a distinction,
Only on the
can be
Well,
distinguished.
I have
It is birds of competition.
But that's why I have said in my at the outset itself, my lord. Only on the point of that competition, then on merit to my lord, but on merit, my lord, these are the because there was a protection. There is a protection of this honorable court, subject to the outcome, and subject to the outcome. My understanding, my lord, the apex court also has said that this protection. How the relief is to be more than that. My lord, that's that. Public interest, evidence is also
That is what?
about this, my lord, subject to outcome, my lord.
One.
This is for what we subject here.
What is that?
This is saying, this is 2019. This is 1.8, my lord. Small, para one in. Para one in. Saying, my lord, when there is subject to the outcome, it is again to be like interim order of the protection. Therefore, the judiciary was
Unfortunately, lots of perspectives.
but this too only enough. This first judgment, my lord, saying, my lord, that if you are exercising accommodating other, have ought to extend that benefit to other also, my lord. You are working as a site, you don't have any idea of that laboratory technician. But you have to taste the soil, all those things, madam. Now, all the time you are working in the field, all of a sudden, how you can become expert? You have never worked in that field. But this is what my understanding of this requirement now.
So what about your
First,
in charge? Just wait. What about your in charge? Lab in charge and tech technician?
well, they work as earlier as a lab in charge, lab technician.
So what?
Yes. That's okay. That, right, engineer, but these persons which you have shown, as a lab technician and lab in chair, lab, their individual basis, they are said, they are on.
Passport does, nobody put the.
They're working. But they speak, 150. What? Yes.
Citing. If I read completely this one, now what is definitely some language may be there, but meaning, my lord, from where, what can be gathered from this? It's a meaning what we can gather from here.
They must be shown.
They-
Experience in left chair, they what we are trying to.
My lord, now, my lord, otherwise, now,
If we accept that the requirement is the experience in both works only.
Right.
And you are not saying that they cannot be, they don't have the knowledge or they cannot be, they have the left chair, the left technician. They are with the.
it is their own admitted case. I even don't, what I am reading here is that they were working as a side entity. Now they are proposing now on, meaning thereby itself says
Therefore,
they have never worked as a,
yes, therefore, it's not a question of never work. There's no experience requirement of 2 years. The experience required is experience in road works. They, if you are not saying that they are not eligible, they cannot be engaged, and they cannot be eligible.
Well-
Plus, it's trying to say that since they were working as a site engineer, so they can be engaged. They may have the knowledge, but if they don't have the experience of 2 years, then what you're trying to say,
Well,
right?
well.
What they are saying, number one is not pleaded, yes, clear cut pleaded case. Number two, even if they don't have the, so to have experience of 2 years, so the lab in the chair or technician, see, they're the engineer, they can be engaged, because the requirement is the experience in what work, not the 2 years requirement, experience in what, only in the road work, not in lab in chair or lab technician.
well, this is the, that's why now my lord will have to read out his experience in both work. Whether this is saying that you, earlier you were working as site engineer, now from today onwards, you are eligible under this clause. If this, but my understanding of this reading, my lord, this clause, my lord, if I read it, my lord, even if you for the blaster, my lord, it says that road works. So, my lord, only because civil engineer working is a road work, it doesn't mean automatically he will start blasting, my lord.
No,
No.
what is required, we have to, what, you don't set your.
For a blaster, you have
So,
blaster license.
then,
That's why I had, I had to ask, but I had not noticed that experience in road work.
Right.
If it is in road work,
then, my lord, if it is so, because they are saying that you don't need to have any experience in lab in charge or lab technician, then if it can be interpreted in that way, then to my lord, they have fulfilled. But my case is that no, one need to have, my lord will say that lab technician, even ITI qualified is, that is not there.
it's not IIT, it's the ITI.
ITI qualified.
That's why I'm saying it's not IIT, it's ITI.
ITI, but even that is not there. With them,
Diploma is there.
diploma, my lord.
Yeah.
So,
More experience.
that's why, my lord.
I don't- IIT.
So, my lord will see this one only, my lord, these 2 years, whether it's sufficient, you're working as a site engineer, that can be counted as a 2 years?
Because it says experience in road work.
Well, if it is so, well, because it will have,
In relation with the.
well, it will have
technician and they will check.
well, it will have ramification for the future.
It's
tender.
not a requirement of experience of 2 years in the
Let-
technician or the technician. But the experience in the road works in relation to them in charge.
And that has to be read, my lord, in consonance.
This is
with the
my
personal
understanding.
qualification.
This is my understanding of this clause, my lord. One, of course, of the road work, but this, so my lord, either lab technician, lab in charge, plus everybody is doing the road work. But even in road work, my lord, there is a separate fee. Some are doing the laboratory testing, some are doing this lab technician, some are driving the vehicle. So this is my understanding, my lord. My lord, with this, my lord,
I have understood. Let me apply my.
My lord, just for my lord, since my
that's
learned
why work quality is compromised, my lord.
are going my lord, beyond the pleadings, my lord, to kindly page 7 again. Is giving an example of the plaster for road escape. This experience in road work will have to be understood in consonance with the personal qualifications. Your lordship will see site in charge, assistant in charge, lab in charge, and this lab technicians. In these cases, anybody having 2 years in road works, having this civil engineering or diploma degree, they will be qualified. But this blasted by learned friend is giving us an example. This is a specialized sport. It's the blaster license for that. The whole example is misconceived. That's it. I don't see the personal quality. Cannot be, I have a civil engineering degree and a plastic road. I cannot do that. I have to have a license.
My understanding, one has to have some knowledge, but only on a single day he will come.
No, I have understood your understanding. Equally, I have understood their
Yes,
understanding.
understanding.
Now let me
Well,
spread the
it is
matter.
well,
Let me apply my
Well.
limited knowledge.
it will have ramification for other tender matter also, but
My first submission, my lord, will kindly consider that he has not pleaded.
Yes.
What is the judgment?
Yes, yes. I have already noted down. I have
What
noted.
is case here, but
If you are to furnish.
if that was pleaded, I would have come ready for it.
Yes.
That is the,
You furnish.
yes, I will. All right.
Hard business. Are so much than possible. Item 7, eh? So. For number 1-4.
Nobody says. Hopefully by the time the judgment for the votes will be complete.
Item number 8.
Spot number 2. You have filed already. The
Yes.
office note says that you have not filed. 2 and 3 have not filed. Have you received a copy?
It's your lordship.
Or has filed?
Lordship, there's a copy of respondent number 2 and 3 as well. Yes, your lordship.
You might have served it. Is there? Although copy of counter affidavit on behalf of respondent number 2 and 3 stated to have been served to the then concept for the petition, Mr. Arrest number, then additional advocate general service that same has not been filed it yet, for which he prays for a week's time to file. Yes, affidavit, counter affidavit on behalf of respondent. This the material after a week. Have been there. Still respondent, actually, counter. Yes, of course. Apply.
Item number 9.
Yes.
So we have taken that step.
What things? Your requisition was dismissed. Right,
Yes, earlier it was
dismissed.
earlier.
Now, what is your grievance?
Your Lordship, in this writ petition, we have numerous of new development, and also the facts that was not before brought before this honorable court was in this petition. That's why the honorable court has issued a notice.
So what is your right now? Your writ petition regarding allotment, this has been set aside. I mean, dismissed. What do you want? What do you want now?
Your Honor, the ground for the dismissal was that the plot of land which we possess was earmarked under the advanced landing ground. It was their condition.
So
But right now,
it's a government land.
Your Honor, no,
Whether it is earmarked for airfield area or not, you are not concerned. First, you have to establish that you have a right to be allotted.
Your Honor, we have been
Whatever the affidavit, madam,
Yes, Your Worship, we're waiting for the affidavit.
not Mr. So-and-so, the counsel.
also,
Petitioners,
yes,
as prayed for by MS Isangita, listed counsel, that this method will be set up for 3 weeks. So as to enable people counter affidavit on behalf of their respondents.
Item number 10.
You pray that this method doesn't listed before this court.
Sure, we need some time to file affidavit.
Yes. Competition has been dispersed.
Yes, but the petitioners haven't received in protest.
Huh?
The petitioners haven't received in protest.
You have received.
No, we didn't receive till now. It had been dispersed, but we are protesting it, so we didn't.
You not,
Mm.
you are saying that it's less.
Actually, they haven't.
Less.
They haven't assessed as per the provision.
But still, it's a very important project.
Important, but I guess the indigenous people are more. They are the owner of that land, and they should get the proper compensation as per the provision.
Frontier highway. Don't disturb. It's for who?
It's for us, but your lordship, but we should get the proper.
National interest is there.
They are
Not only handful of the people.
Your lordship, national interest is there, but we should be the people who should be the person who should get the proper compensation at first. Because we are not asking anything more. We are just asking as per the provision.
Are you sure it's either your land?
Yes, we are sure because
then
we are sure because we are staying there for
you know what? Claims made by other than the citizen of the country. Beyond the border.
Your Lordship, but we are staying there for time immemorial. So we are the people who
Think about the national interest first.
we are thinking. We are not saying that
You are getting something.
we are, but not as per the provision. We should get as per the provision. We are just saying that we
We
are.
are clear.
Yes, we are not.
We find that you are getting more than as per the provision.
We are not against the giving of the land. We are just asking. We don't know whether we are getting more than that or not, but it's not as per
Show
provision.
us this is your land. Any document.
But state
That's what I'm saying. Don't let us go into what is, I mean, exactly what is your right.
Your Lordship, the states even they don't have that is their land. We are staying there, so we are the people.
So what you are getting more than what you are entitled.
We can't say that, Your Lordship.
Say about the national interest part.
We are thinking that's why we are not against the project. We are just against the compensation that they are providing because it is us against the provision which is given in the statute. So we are not against. We are just saying that give as per the provision, assist first land as per the provision, then we are okay. We are not against it.
I'm not saying that law has to be bad, but then there's certain areas, certain issues.
Yes, I
It's
understand.
not about only your individual interest.
No, Your Lordship, it's not about the
That
individual.
interest has to be taken care of,
Yeah, it is not about the individual, but
rather than the handful of people
it is for us.
who
So
is
first,
agitating, despite getting the, I mean, benefit more than what they deserve.
Your Lordship, it's not just.
Anyway, not MS so and so, land council for the petition. I'm just indicating
Yes, I understand. That's why we are not against it.
for the prayer of our Basa Land State Council. For that, she said it that file the petition on behalf of the state response.
Yes, Your Lordship.
It's very, very important.
Yes, we understand.
Because it's for all of us.
Yes.
Item number 11 and 12.
Madam, other day, we have appointed you and you were not present in other case. Okay, where's the petitioner?
Your Lordship, regarding the other case, I'm sorry, but there was some kind of miscommunication between us.
Maybe.
Yes, that's why. Otherwise, I would have appeared.
Your Lordship, petitioner leading counsel will hear through PC, Your Lordship. Appear through.
What to do? Beyond everyone. What?
The next step,
It's very difficult to.
it is their difficulty to enter reports court.
My lord.
Yes.
What your
Day after tomorrow,
okay, your
please inform,
okay.
will not adjourn further. Will it be convenient? Day after tomorrow,
Obligers.
request him to come.
Okay, your
Physically present with Arguda method. There's a network issue. Everybody knows, still then,
Obligers.
okay.
since the Mr. Swenson and Council. No, due to technical glitch. Come on, better, could not be taken up for Zoning. As the Lalit Council, Mr. M.K. Singh. For the applicant. Is unable to. Number one, number two, which number two? Two, number,
Two and three.
and again, then the legal counsel, it's one number two and three. Mr. You got it, then counsel for the student. As well as Mr. Shakespeare, assisting Mr. M.K. Counsel. Are present. This to the chance. After tomorrow is 20. This was a comment.
Obligers.
In fact, we have heard the grounds and that is the thing. It's a big from that. And sure, huh?
Item number 13.
No steps. Step has. Wait. Wait. Yes, no, no. Senior counsel of. On 12/5/2025, you have, paid for. Step, therefore attempt to take fresh steps. Correspondent number two. Not, as I have gone through this, affidavit, filed by respondent three. There it is, I Sri Rajesh Kumar Singh is about so and so, serving as principal chief conservator of forest and head forest of the forest. Sir, my lord. As per the writ petition, the respondent number, now the present respondent number three. Respondent number three. Respondent number three is taking the charge of respondent number two. Respondent number two has already been transferred. So he is representing respondent number two also. How can he represent respondent number two? But are you saying that the respondent is not a missing party? It's not a LS contender. Lordship, in writ petition, respondent number three is principal secretary of the department. But see, if you want that this respondent to is not an LS contender, then you file an application for striking off. And if you think that he has violated the course of the necessary party, then you have to take this step. Lordship, earlier, the respondent number three was the principal secretary. Now he is a chief conservator forest, which is replacing respondent number two of
GV negative. Who is
How
all?
can he represent? Are you saying the respondent number 2 is not a necessary party? If you don't have any grievance, that in the, it's a contempt petition.
Yes.
For an application for extraction of this respondent number 2. Will extract it out.
Yes, yes.
Are you sure?
Because here, as per the affidavit filed by.
Don't go by the affidavit. You think about whether he is also a person who has violated this court order.
Yes.
Then
But as per reliable sources, he is already transferred from the post.
what is to be done?
This moment, the competent authority responded about.
Although office note indicates that petitioner has not taken steps for respondent number 2. At least contender number 2. Is prayed for. Not by this court, comma. Mr. So-and-so, learned counsel for the petition submits that he may be allowed some time to file an appropriate application. Appropriate application. Is this matter? 2 weeks. 1 week, 2 weeks.
2 weeks.
2 weeks.
Item number 14.
Here, respondent number 3, they filed their affidavit. The rest of the respondents are yet to file their affidavit.
We have already filed our affidavit for 3, 4, and 5.
We need some more time for we need time for filing rejoinder.
Yes, what is to be done?
You know, I need time for filing rejoinder.
Rejoinder.
Yes, Your Honor.
Mr.
H time.
H.
Time.
Thai learned counsel for the petitioner submits the learned counsel of the petitioner. Press for an is granted whether press for an granted 2 weeks time to file affidavit in reply. To the affidavit opposition file on behalf of respondent number
3, 4, and 5, also we have already filed.
4 and 5. Who else are appearing? Serial number 1. MS so-and-so. Then Mr. 1 Professor. Then 3 and 4.
I'm for 3, 4, and 5.
Additional,
No,
not as a learned counsel or additional PP.
as additional people,
Additional correspondent 3 and 4,
3, 4, and 5.
3, 4 and 5, and Mr. Titago 4. Respondent number 5 are present.
Right.
Item number 15.
No affidavit. Still, affidavit is required. Six to 12. Affidavit.
When
Yeah.
I filed the affidavit, I had raised an objection. Upon investigation,
Yes.
now the question of maintenance, the water implementation of Kempa project, and we have solved, we have solved
You are for respondent number
6 to 12.
6 to 12. Yes. Yes.
We tried an agreement to something other documents. And we have clearly mentioned the name of the state, and we have solved the amount of that. But now, again, there are 42 questions. There also planning the
You are favorable respondent. We need a response from the state, sir. We'll consider your submission. Is listed for orders. How many years?
Your Lordship, we have received a instruction at least 2 weeks time may be given, Your Lordship.
Why not 2 years? Art Mr. So-and-so, Learned Counsel for the petitioner. Mr.
K Tabang, Lordship.
Huh?
K Tabang.
Next pair, Mr. M. Pertin, Learned Senior Counsel, assisted by so-and-so. The public Learned Counsel. For respondent 6 to 12. Submits that an affidavit of opposition have already been filed on behalf of the both respondents. On behalf of the respondent was 6 to 12. Next para. And also and also has raised the maintainability of the writ petition. Mr. MSL TP Bangu Learned State Council submits that she has received the instruction for which she seeks for a 2 weeks time to file affidavit.
Meantime, Lordship, I will file
Yeah.
rejoinder against the reply of this
So
private.
it's fine. Prayer of the London State Council is granted. Let this method be listed after 3 weeks. In the meantime, parties may exchange their affidavits.
Item number 16.
Service awarded against respondent number 20.
On behalf of respondent number 4 and 5, we have filed, but on behalf of respondent number 2 and 3, I need time to file affidavit. Four and 5, we have filed. Two and 3.
Item number 17.
We are saving some more time, saving some more time to file a region.
What's the? Surviving issue. Still any surviving issue? Is there any surviving issue?
But, respondent number 7, I think.
So I'm asking any issue to be determined?
Yes, ma'am.
Is left?
Yes, ma'am. We have filed in, but it's been opposition. So, that affect my
There was service report in respect of respondent number 7. Next para, Mr. JCB then constant for the petitioner. Respondent granted. Weeks time. Right, they will reply. The affidavit of opposition. Well, on behalf of the one system of the feeling. Mr. Vitar understanding process. And the president.
Item number 18.
I am appearing on behalf of the petitioner. Earlier hearing on 26th May, the petitioner made a prayer before this honorable court to take the steps upon respondent number 9 and 10 to justice, which this I have already taken and filed the affidavit on 29/7.
Yes, affidavit you have filed.
Yes, Your Lordship, 29/7.
What? The tender matter what?
Regarding road realignment, road connectivity.
So. Where's your affidavit? When did you file the affidavit?
Affidavit was filed on 29 July.
Where it is? Affidavit filed on behalf of petitioner regarding service of notice. Where it is? Where is the affidavit? Yes, yes. By who?
Received by respondent number 9. Respondent number.
By me?
Yeah, we have sent taken steps justice to the by hand.
Who is this Nako Hassan? Is it Nako Hassan? Is respondent number 7?
Your Lordship, 9.
Nako Hassan.
We had served the copy in the office of the AC. APPW. Where the respondent number is working with it.
No, you have to take the name. I mean, by a destiny means why? You cannot send it to somebody. Nako, who is Nako Hassan? Sana Nekamtara, President Service should be
It was received employee of AC of
and respondent number 10.
that is the proprietor of the MS Kenge.
The name is what? David Chetri. Not the proprietor again. Huh? What? Not show somebody. Okay. You have to take this, take steps.
Then we still, then they can count it with someone else. I break on the basket.
No, once you are allowed to dusty, you'll have to take to the person only. Not to somebody.
Okay.
An affidavit has been filed. Respect of response to the file. Get to the step forward. So that what Marco has said on behalf of what the office, what Marco has said. By the respondent number 9. And also on David's entry, not by the proprietor of the MS respondent number 10. That's very about. Petitioner has taken steps that must still want the respondent number 9. And then they spread for the petitioner that this is just for so this is purpose of the respondent. By negative by testimony. Okay. After
Item number 19 and 20.
Item number 19, by order dated 4/8/25, the state was directed to file affidavit relating to a survey, field report. And I think service upon respondent number 6 and 7. That's GM NHPC and GM Divang Multipurpose Power Corporation are yet to be served, but we have taken necessary steps, my lord. Then I will await for the report. And yes, and yes, my lord, then actually like in earlier proceedings I have filed the power, but my name was not shown. Yet we have filed a fresh power this morning, my lord.
the last order was, since you have received the good verification survey, maybe brought on record by an affidavit of by filing the affidavit. Your detailed affidavit is submitted. First, bring on record. Field verification. Because you have already received. It's the order, I have received the order. But since for service the director has been carried out, for which a report has also been received by him. The junior becomes sometimes bring on record the report by when affidavit. Only report you bring on record. No, that will be enough. May not, you should bring on record. But then one week. Noted claim.
Here below that, the petitioner in the item 20 filed one IA for implement which was not allowed by this honorable court. So they also have, but then the appropriate forum for them would be before the deputy commissioner.
The item 19, huh? They had this, that person taking petitioner. Petitioner or petitioners? Petitioners. Petitioners. Office. Office not paper. Second supporting those payments, number 6 and 7 I'm still awaiting. Next para. It's called on 04 we consider the implementation of the beginning has simply been self-verification survey. Why? Is the matter along with WPC 35 of 2025. In item 20, huh? Right? Okay. 69. Sure. List along with, list the matter along with second step. So that's where what 629, yes, second steps. Order dated 6/6. It's not uploaded. 0408-2025, Victoria. Just inform her. Must have missed out. Then there's no effective order. Only time was granted. Maybe because of that, he is not fine.
Lordship, this after 3 weeks.
3 weeks. No, you did 3 weeks, right? 19 is 3 weeks. So we said list along with WPC 247 after 3 weeks.
Item number 21.
Yes, ready. Yes. the impure order. Cover 16 10. Village level के बाद but then Gawapura GBs were there. HGB was also there. HGB who Henjumjora was also there. How do you agree by this? Don't you agree to this? No, are you agree by this? It was filed. Against this, have you filed? Circle head counter. But then the HGB and GB were there. You have agreed to have a settlement, which includes may not be technically a keba, but then you have agreed to with the meeting to decide by a amicable settlement. So they have settled it. If you are agreed, how can you be allowed to claim that this was not a keba? There cannot be, there should not be. You should have immediately objected to the decision. I mean this settlement. Why you have protested this? Did you appear, have you participated? You have participated. Your name is here, serial number 29. No, why you have agreed to participate? Why you have participated in the settlement? Why it said it? By this settlement, what does it say? What the dispute should be conducted? Yes. No, according to him, this was a family settlement. It's not by a kebab. 88. The proper language for grammatical thing by the circle officer. Therefore, you are advised to withdrawal of Parwana suit for fixation of Java with the correct language for a circle officer. Yeah. View of the enactment of civil code. Which not agree to? You are not agreeing to the settlement. Huh? You are larger. Why the title should? What the civil code? Gambura, head Gambura. Why you have mentioned LGB? Why you have made it into? It's not an agreement kind of family. It doesn't say family settlement. It's a Keba decision. Why you have said Keba decision? Should have been said. It should have been Keba the family settlement. Notice. Who has given the notice? No Parwana is required to be issued from me on your depot email version of your annual meeting. The matter shall be decided as domestic discussion on an your directed. Where it is that Yes. Yes. Let us see the original now appeal will go to where now? Civil court. You are objecting to the paper. No, no, decision is in your favor. very young lawyers who are what strategy. I have heard it, keeping for heart. For you, they have to for you. Okay. But dispute. Or you may discuss with him, will allow you to file appeal. Will not was your goal. You fight out with the appeal. Not Mr. Because you have not signed the Mahalat Tapa. It's all problem. Your senior client may get you. There's so many lawyers. But
Item number 22.
yes, you consider what is there. Filing or dispute? Yes.
Your Lordship, when the petitioner first entered this honorable court by the virtue of his petition, our only concern was this. We were asking this
You are
honorable.
placing your application before the appropriate authority.
Yes, Your
Now,
Honor.
in view of this order, the notification, since you are a temporary WC employee, your father.
That
So this doesn't apply to the compulsory appointment, this for regular, who has died in harness.
Your Lordship, if I may continue humbly, Your Lordship, had we received this rejection order, rejection letter, I may say,
Cannot.
Your Lordship, my submission is this: had we received this rejection letter before filing this writ petition, we would have never filed this writ petition. Rather,
So what to do? This is, when did you file this petition?
Your Lordship, this writ petition has been filed after issuing 3 continuous response
It's okay. When did you file this?
last year, November 2024, Your Lordship. November 2024,
So this was issued or communicated to you on 21/2/2.
we were never communicated, Your Lordship. In fact, the counter affidavit is silent in this regard. Counter affidavit only makes it explicit. Not a matter of right, matter of discretion. We understand, Your Lordship.
It's a
Hence,
question.
yes,
Now it has to be on the basis of states.
yes.
It's not a rule as such. Now the scheme doesn't provide, I mean, it goes the temporary deficiency staff. And you have.
Your Lordship, this-
Your doors are not shut. The workman compensation like it's applied. Even the probate.
Your Lordship,
It's of no point, I mean, carrying on this, when it was filed, not completed, so to me.
Your Lordship, but that
You are the relief. How do you, I mean, provide your relief? You are not entitled because of this technicality. I understand.
Your Lordship,
Despite-
that is disputed.
Yes, but despite not have been complicated. That is, it has not been done. But what you do? The basic thing we need to adjudicate is you are, maybe you are entitled for consideration of the scheme.
Your Lordship, that comes to the second.
All right.
Your Lordship,
Therefore-
I will pray for being heard, Your Lordship, on one aspect.
No, it cannot be heard. Your simple case is that your father died, who was working as temporary WC staff.
That is disputed, Your Lordship.
Huh?
The widow is receiving even pension.
It's okay. There is something, it's not a regular. It's not a regular. It is only for the regular. You may challenge this in that case.
That's why, Lordship, that is my sole allegation today. Our petition has taken altogether separate stand today, Your Lordship. Had we received this order,
See,
we would
there must
avoid
be a
this
basis for granting a relief. In view of this, see, we understand they should have considered your case.
And
It
it's
should
gross
have been
negligence, Your Lordship.
immediately communicated to you.
Yes.
Nevertheless, this has been communicated.
At
Not-
the expense
not
of
by
this
them,
petition,
but
Your
then
Lordship.
anyway, it's okay. It cannot.
Your Lordship, I will just make one last consideration. After it, I will not press anything. Whatever
No,
your
no, it's
lordship
not
may-
a question of pressing. I'm just advising instead of, having a thing, you avail the appropriate remedy. If you think that, if you disputed that the temporary WC staff, can be considered, include a temporary, you may challenge this,
That is exactly my prayer to the lordship. I would refrain from litigating further, rather alter good efficacious remedy to file again representation to the rejecting authority for consideration. If I feel I am not being heard properly, I will approach this court again in an appropriate manner. However, your lordship, one thing what gives us feeling of hurt today is that when the respondents have been cast upon with the statutory and the constitutional imperative duty to dispense this duty to inform the
sir,
citizen.
let us not go into.
There is a ruling of the Supreme Court, your lordship, Honorable Supreme
No, no, it's not all the case.
It says that the non-feasance on the part of the state actors must be strictly scrutinized by the judicial forum and appropriate remedy
It's
must be
okay,
issued.
I've understood that. You may be correct. But in view of this consideration, wrongly or rightly, you have to challenge this.
I will, your lordship, and my prayer has become infructuous today. I'm
That's what
admitting
I'm
it.
saying. That is what it trying to.
But only one thing I will consider today, I will abandon all my prayer, your lordship. Because this infructuous has not been done because of the non-due diligence of the petitioner, but non-feasance and silence on the part of the
Nobody
respondent.
will stop you from challenging this communication.
Sorry, your lordship, I'm pardon.
Nobody will stop you from challenging
Yes.
this communication if you feel that this rejection of your claim
Yes.
is not tenable under the law.
But one thing must be done today, lordship, to secure both ends of justice.
Today we cannot do anything. Only we can give you a liberty to avail the appropriate remedy.
I'm ready to do that, your lordship.
That's all.
But your lordship, cause becomes imperative today
No, no,
because your lordship, they have remained silent throughout the year.
no.
And
Have you come across? You have filed this writ petition when?
sorry, your lordship,
When did you file this writ petition?
2024 November.
November.
And before filing this,
Have you come across how many, what is the oldest case pending here? Where no affidavits are being filed?
your lordship, I'm not telling that. I'm not talking
You
about
have to tell it.
Your lordship,
It's one of the, it's not, you cannot say that it's been delayed.
your lordship,
I
I'm not saying
understand
the
they
judicial
have-
procedure has been delayed.
No, see, after filing of the writ petition only, you have activated them. Accordingly, in
23.
they find it out. 2024, they find out the record and this communication has been annexed.
One intention is implicit here on the part of respondent number 3. Your lordship, we truly appreciate on the part of the respondent number 2, superintending engineer. Oh Lord. No, Lord. But not intimated, sir. Not intimated on my.
Wait,
Your lordship,
have you communicated this?
there is no proof, your lordship.
Have you communicated this?
And it is silent on the affidavit also. They never says it was communicated. They just says that it was disposed.
Sir, have you communicated this? Where it is?
This is truly misleading, your lordship, now.
Have to dispose of the limited revenues and booking get their by. So it's very No, where you have said that you have communicated. Unless you communicate the order, how can the
challenge?
Serve that, Anyway, we'll not go into all this thing. Ultimate is you are claiming for consideration appointment. As of now, as per the privacy, as per the office memorandum, issued by chief engineer, since you are a the temporary WC staff, it doesn't cover, the scheme doesn't cover the.
But Your
temporary-
Lordship-
Now, if you think that it covers, you may file a.
But Your Lordship, one question remains today after this pause. Is this judiciary so
No,
helpless
no,
that it
that
won't
is
be able to put even
Sir,
punitive damage?
You are a promising young lawyer. Don't just harp on all this. Don't enter to this. Don't venture into this arena. Very, very hard. Time will come.
But Your Lordship,
Time
this
will come
requires
with
today.
appropriate cases.
I believe, understand Your Lordship. But
Sir,
Your Lord-
time will definitely you will have the ample opportunity in future to venture into all those arenas.
Yes, definitely.
Wait for your right time.
But Your Lordship, today it's not
You are
about
too
me.
early to go into all these things.
Your Lordship, it's not about me.
It will rather, rebound on you.
Your
All
Lordship,
right.
I believe I have the indispensable duty against the petitioners
Yes,
to.
yes, we understand. Yes. So withdraw. You said infractions.
It got in uh, the main subject prayer got infectious, I admit, but at the
That's
hands
right.
of the respondent,
That's why it should have an effect.
I will evaluate. I will only pray for one small prayer, Your Lordship. There is at least, even if not punitive damage, at least the cause of the suit, cause of the petition, Your Lordship, because
It's not a civil suit, sir.
the cause of the
It's a rate
petition.
petition.
Yes, Your Lordship, cause of the petition, at least, Your Lordship, because we would have never come to this honorable court, rather appeal that, as Your Lordship has rightly said,
Yes, that's why I'm indicated.
but they have compelled us to come here, Your Lordship.
Don't compel me to comment more. I'm indicated for your healthy career. For your healthy career, we're looking forward.
Truly, Your Lordship.
So, lots of possibilities.
Yes, that's right.
Yes.
I was only expecting this court to issue us at least the.
Yes, sir. What do we know? What is the report? There are different level.
There is even judgment of the Honorable Supreme Court.
See the civil appellate report. Same court. But where is the report?
And Your
There are
Lordship,
civil jurisdiction.
and Your Lordship have
Courts are there. Criminal courts are there. So it's not all the courts you can have to all.
But Your Lordship have been vested with the true legitimate power today to at least grant us the cause of this proceeding, Your Lordship.
That's why I said I cannot. That's why I try to understand.
In Your Lordship, this petition may be dismissed on the ground that the prayer has been.
No, we'll not dismiss. We'll say that better you have submitted and better have the report. So you have to reply made by the state.
Yes.
Therefore, you will be allowed to withdraw.
Even other alternative. Your Lordship, one thing may be observed in the petition so that I can satisfy my client also honestly that I have praised for the.
Sir, it's not a question of, as a question, we are, human consideration, particular score text, but then, text care, but then we go by the law. They don't go by the emotions and all the sentiments. Otherwise, the whole system will collapse.
Your Lordship, I will just pray that this observation may be made in the order that the council have
I
prayed for the.
understand you being a young lawyer, very enthusiastic and promising. This is something we appreciate it, we encourage, but in accordance with law. All right.
So Your Lordship, one
Our
observation
Mr.
made. Your Lordship, observation may be regarding.
In some other appropriate cases, we'll hear you. When you say that it is infractious, nothing remains to be heard.
Because of the response.
Heard Mr. Lombe,
Margelombi.
Marga Lombe, then counsel for the petitioner, who fairly submits that in view of the response, in view of the response by the state respondents, whereby the relief sought for has been considered, has been addressed by rejecting the claim of the petitioner, place the matter before the appropriate authority for appointment on compulsory ground. And in view of the office memorandum dated so and so, what says office memorandum?
There are two, Your Lordship. One is office memorandum, one is rejecting letter. Which one, Your Lordship? The office memorandum. Reject.
That consideration by communication dated 21/02/2024 based on the memorandum, office memorandum dated 26/07/2006, whereby the member of temporary WC staff are not considered for appointment on compulsory ground under the relevant scheme, relevant policy of the state, rather would be covered under Workmen's Compensation Act 1923, he may be allowed to withdraw this writ petition. The matter has become infraction, right?
Infructuous, but
First I said that matter has become infructuous. Therefore, press for withdrawal of the writ petition with the liberty to approach the appropriate forum. It's your advice. So, Mr. Del Perme, and his stating counsel for the power department is present. Having been, having considered that the little has become infructuous. That is the prayer for withdrawal is accepted. Stop accordingly. Writ petition stands withdrawn, closed on withdrawal. Closed as infructuous. Okay. Liberty to approach the appropriate forum is maybe permissible under the law. That's all.
much obliged, Your Lordship.